The cross-examination of Pravin Gordhan by SARS Commissioner Tom Moyane's legal representative, Advocate Dali Mpofu, earlier this week at the state capture inquiry was a hostile affair. Let's listen to this chunk of their exchange.
Mr. Moyane his version of where the hostility came from has got 5 elements. Firstly, he says it was caused by your, what one might call general arrogance towards him. And then he says, secondly, it was caused by what he terms petty jealousies about his role at SARS. And as I've said, those are issues I will touch on very briefly, but those are not the core issues. Then thirdly, he says it was also, it originated from your racism towards him specifically, and maybe towards African people in general. And then fourthly, he says it was motivated, and that is where we come closer to the meat. He says it was motivated by your desire to deflect from your own involvement in state capture and corruption. And then fifthly, he says it was because he blew the whistle on the mass trail of illegal activities and corrupt activities that you left behind at SARS, including the issue of the rogue unit and the alleged early retirement of Mr. Pillay.
As we delve deeper into their behavior, I'm joined by Angelo Fick, the Director of Research at ASRI. Mr. Fick, a pleasure to have you on the program this afternoon. Now, you've been listening in on that previous soundbite, and in reaction, over the past few days, the media has been dominated by headlines along the lines that Pravin Gordhan failed to produce evidence of state capture. Some commentators have even suggested that the commission is a farce and Gordhan should be reshuffled. What did you take from this week's proceedings?
I think there were several issues, including those raised by Advocate Mpofu and those raised in your question right now. I think, firstly, we need to distinguish between the judicial process and what counts as evidence in a judicial process, whether it is in a court of law or judicial commission of inquiry, and what would count as evidence in our everyday lives. And there, I think, observers are correct that the kinds of evidence that we would have expected to serve at a judicial commission to prove the accusations that people are implicated in malfeasance, maladministration, or some form of criminal activity would have to meet the legal requirements for evidence. And their rumors or media reports are simply not enough. A paper trail of documents, exchanges, those would have been necessary. Because it's one thing to suspect somebody of something, and it's something else to accuse that person in a judicial process of that if you don't have evidence of the sort. And there, I think the strategy by the cross-examining attorney may have been to try and draw out from Mr. Gordhan that he did not, in fact, have evidence. As for Mr. Mpofu's accusations or attempts to prove the accusations by his client that there was racism involved, again, in a judicial process, particularly in South Africa, where racism is so rife and so widespread and such a specific blight in our society, one would have expected there to have been more substantial proof of such racism than the kind that was offered in that process.
I want us to expand on this and also probe Mpofu's racism analysis. He argued, among other things, the use of the word cheeky alludes to a certain element of racism, accusing the minister of being racist. What are your thoughts on this?
So I think while there may be some kind of underlying understanding that certain terms, when used in public by people who are read as belonging in one Apartheid Population Registration Act category, in relation to other people in a different category, could be construed as racist. It is very dangerous when we start removing context from this, and that would be the context of the particular moment we're in, as well as the particular individual speakers. Advocate Mpofu's delineation of different kinds of racism also left me slightly baffled, because I think it is important that on issues of racism, or any other, kind of issue of difference, we relate our understandings of these things to scholarship rather than to popular cultural constructions based on a supermarket incident, based on the estate agent's behavior, and also to reduce racism to simply one of attitude and verbiage is, I think, disingenuous, because there is a far more complex debate on racism that has been, around for at least a generation on the relationship between individual actions and the structural support that such attitudes and actions have in the society that one lives in. And here one thinks of all of the work done by people like Angela Davis, people of that caliber, to look at the intersection of race, gender, class, and the relationship between local racisms in places like South Africa and global racisms as they re-arise around the millennium. And so that for me was an odd moment of delineating, because that didn't seem to be an attempt to outline conceptions of racism for the chair of the commission, but seemed much more to be about playing to the gallery and playing to the public audience watching the proceedings as they were streamed.
Now, so much of Mpofu's discrediting or criticizing Gordhan's claims relied much on Mpofu's assertion that Gordhan's claim that Moyane aided the state capture project was mere gossip, devoid of any facts or proof to back this claim up. But what did you think that Advocate Dali Mpofu actually achieved at the Zondo Commission this week?
I'm not going to comment on what he could have achieved or did achieve in terms of legal process. I'm much more interested in, given that the proceedings were broadcast live to ordinary South Africans, how ordinary South Africans get to understand not just the issues of racism or state capture that was raised, but the very issue of judicial process. And I think for well on a decade now, South Africans have been encouraged to think of judicial processes the way they think of television drama. And for me, one of the key moments where that shift happened was the Pistorius trial. And one of the people involved in a debate at the time, who was a serving judge and still is, raised concerns around, Justice Davis raised concerns around whether this would lead to advocates playing to the public gallery rather than arguing points of law. And I think over the years, we've seen increasingly that there is the bleeding in of non-judicial modes of engaging and much more political and popular cultural notions of engaging. And while ordinary South Africans in their millions have everyday experiences of the court processes, they also have mediated experiences through television drama, through film. And my sense is that people are beginning to conflate various judicial systems, the American, the British, the South African, and various popular cultural representations of that in television drama with what they're seeing in front of their eyes. And there, I think it would be important for the officials in the judiciary to try and balance out the need to educate South Africans about judicial processes and maintaining the judicial discourse of these processes so that they do not become mere political rallies and rhetoric begins to be valued over logic.
That's a very interesting observation you make. And judging by the likes and the number of comments coming on sites like Twitter, for instance, South Africans seem very interested about the processes that are playing out at the state capture hearings. What do you take from this level of interest?
So if one takes the caveat that these social media platforms represent a minority of South Africans, and often people with access to data, and that it's a skewed sample, what I think we can take from it is that many South Africans, many of them very highly educated, are doing this conflation of assuming that what they see on their television screens when watching a television series about law, of the kind that somebody like Viola Davis acts in, and what they see when something in the immediate environment that has real political consequences for how we proceed in the society, if that is read in the same way, whether somebody was convincing, whether somebody was particularly good in terms of their performance, rather than whether they argued the right point of law, we run the risk of South Africans conflating the performance for the substance. And that, I think, is not a good strategy to go on. We already sit with a society in which critical literacy is a problem, in which basic literacy is of some concern, and in which the construction of the state in law, that law is an active language. And so the careful use of language in legal processes is absolutely essential. And then whether or not somebody is particularly convincing in their argument in a judicial process, to me as an individual sitting in a shebeen or in my house, isn't of importance. It's whether or not they've argued the correct point of law and what I can learn about the process and administration of the law through that as a person who is not a lawyer, as an ordinary citizen viewing this process. And that, I think, is part of what is needed for South Africans to understand how the very state we live in is an effect of laws, and that the distinction between the three arms of government is precisely to show that one set of logic works in the executive and the legislative, and that may have some political component to it. But in the judiciary, it really is about the logic of jurisprudence rather than whether or not people perform well under the circumstances. Because you can make a very good point rhetorically, you can make a point well rhetorically, but it is the wrong point logically. And that, I think, is something that judges and lawyers do all the time. And it'd be useful to ordinary South Africans to, I think, observe that distinction between somebody who is flamboyant and well-spoken and makes nice rhetorical gestures, but actually can't argue the right point of law, and somebody who might be dry and boring to observe, but argues the correct points of law convincingly for the judicial process to come to a conclusion.
Yeah. Now, as we wrap up, I want us to reflect a bit on what was said at the actual proceedings. I mean, Gordhan is accused of being arrogant, and it became quite apparent during the tense drill between the pair that Mpofu's strategy was to discredit or unsettle, and some may go as far as to say embarrass Gordhan as a witness. Was the minister expected to simply roll over and allow himself to be bullied, like some allege?
I think here again, the reduction of the process to conflicts between personalities, which it had been set up before we'd even heard from either of these people. If you go back to last Sunday's newspapers and radio and television reports, it was this great conflict between two personalities. I think that reduced it to what actually the process was supposed to be. The State Capture Commission isn't there to find people guilty or not guilty. It is to glean evidence and begin to construct a case for what had happened over the last 9 years in South Africa's politics and state formations in order to decide what judicial processes have to be followed. And for that to happen, clarity needs to be achieved about how things happened, who was involved, and what their role happened to be in those processes. And for that, I think very little clarity was provided by the process, either on what Mr. Gordhan alleged about Mr. Moyane or what Mr. Moyane alleges about Mr. Gordhan. And that, I think, is why South Africans weren't necessarily well served and clarification wasn't arrived at. So it'll be interesting to hear what Deputy Chief Justice Zondo in his summation reports, remarks on that day's testimony and that day's cross-examination.
That was a Director of Research at ASRI, Mr. Angelo Fick.